Swayam Prabha. Digital India. Educated India.
Hello friends, in the present lecture, that is lecture number 19, under the course the law relating to women and children, I have come with the topic the protection of women and children from cyberbullying. The cyberbullying has become the new challenge for the rights and privacy, particularly privacy and personal rights of women and children. In the present era of the science and technology and computer science, when the internet has provided for the new means of communication, newer and newer means of communication are being developed. It gives the opportunity to the individuals, to human beings, to interact in very fast manner and very easily to each other. But the same developments also pose the challenges. Same developments also create the issues for the privacy and personal rights of women. Sometimes we see that these means of communication becomes the challenge or the issue for the dignity of the women and children, and therefore it is important for us to know that what are the different kinds of cyberbullying and how the crime of cyberbullying is now become the challenge for us to deal with. What is the law relating to the regulation of such crimes or such new means of communication whereby the cyberbullying is done or it is made. This topic has been designed for the same purpose. Friends, in 21st century, it has brought the rise in technology and new obstacles every day. Social media companies have brought new means for individual to interact with the world at large, but the lack of awareness of laws and means of safe use of internet make women and children ill protected. UNESCO announced the first Thursday of November every year to be celebrated as International Day Against Violence and Bullying at schools, including cyberbullying, with theme for 2023 as No Place for Fear, Ending School Violence for Better Mental Health and Learning. We can understand how by this kind of cyberbullying the mental stress is given to the children and women. They are not able to face such kind of offences and crimes being done everywhere and every day. As per the Cyber Smile Foundation, US based international non-profit organization, in its report remarked the following, and we can understand by these remarks how serious this crime is. 59% of the world population is internet user. 60% of the internet users have encountered to bullying, abuse and harassment online. 59% of the world population is internet user, and the 60% of these internet users have encountered to bullying, abuse and harassment online. This is the seriousness of the crime of cyberbullying. Cyberbullying takes many forms such as harassment, intimidation, blackmail, objectification, spreading fake information about the individuals, etc. These may be various means of cyberbullying, and these means of cyberbullying includes the harassment of the individuals, intimidation, the blackmail, the objectification, the spreading fake information about the individuals, and the individuals who are the culprit of these various means of cyberbullying are not able, are not in position to respond properly or to deal with the effects or the consequences, to overcome the effects or the consequences being created by such offense of cyberbullying. These all the forms led to the effects that reflect in real life rather than virtual, such as stalking, fear, assault, depreciating mental health, suicide, etc. So, how the cyberbullying becomes responsible for the stalking, becomes responsible for fear in the minds of women and children, becomes responsible for the assault, different kind of assault, becomes responsible for depreciating mental health, and even it leads to the suicide. Many women and children, they are compelled to or they are forced to commit the suicidal attempts because of such cyberbullying or such offences of cyberbullying. Center for Social Research displays all the relevant helplines for women and children seeking care and protection from police, legal aid and counseling. Different kind of methods are being evolved so that the children and the women can overcome with the effects or consequences of this cyber crime in the form of cyberbullying. Cyberbullying is not just a legal problem, but a social issue too. As we have seen in all the lectures of this course, because this problem, all the problems of women and children, it is not limited only to the, these are not limited only to the legal field, these are not limited only to the legal nature, but this is also the social issue. Proper and ethical use of web and social media should be promoted to curb this issue. Always we see when the means of communication are developed, when the newer and newer technologies are introduced, in the regime of right to speech and expression under Article 19(1)(a), which is the fundamental right of everybody to speak and to express by various means. So, internet media, social media has also become the source of the right to speech, a media or the medium of availing the right to speech and expression. Then always there is the issue or there is the conflict. At one side, the right to speech and expression of the individuals is there with or by means of newer communications is medias, and on the other hand there is the question of the protection of the privacy and dignity of children and women. That can be overcome or that can be tackled only, not only by the legal norms, not only by making the laws, not only by developing the regulatory measures, not only by finding out the effective administrative machinery and effective administrative measures to deal with these crimes or these offences of cyberbullying, but at the same time being the social problem, it is important that some ethical and moral norm should be adopted by everybody who uses these newer means to communicate or to avail the right of, to enjoy the right to freedom of speech and expression. It is very well stated that world scarce rumors destroy and bullies kill. Anonymity of users on the internet and public data, available is the cause of cyberbullying. This is one important lacuna, this is one important issue or the point which is to be raised. Many communications are made which are anonymous. You cannot know the name or identity of the author of any particular publication being made on internet media or on social media. Because of the development of new technological tools or new means, the experts of the cyber world, they can disseminate the information, they can make the publication, they can send the information from one place to another place even without disclosing their names and identity. This is a very big challenge for the legal machinery, for the administrative machinery to deal with such a problem of cyberbullying. On the other hand, it has become very grave problem or very grave challenge for the women and children to face such offences or such crimes of cyberbullying. Anonymity of users on the internet and public data available is the cause of cyberbullying, of which women and children are most vulnerable victims. The issue of cyberbullying is to be included within the course of law relating to women and children, particularly for the reason that most of the victims of this cyberbullying are the women and the children, by way of the comments being communicated by such offenders having the illicit or the sexual remarks, by pornographic representation of the women and the children, and therefore this is very big challenge in the life of the women and children. If we talk about the types of cyberbullying, what are the many kinds of cyberbullying? That may be in the form of digital voyeurism. This digital voyeurism refers to the act of non-consensual abuse of intimate images taken in private or public spaces. It also includes sending unsolicited, sterilized images or videos to someone, often known as cyber flashing. The another name of this digital voyeurism is cyber flashing. Under this digital voyeurism or cyber flashing, the act of non-consensual abuse of intimate images taken in private or public spaces is made. And this cyber flashing also includes sending unsolicited, sterilized images or videos to someone. Nowadays, it has become very easy for the persons to use the images of a person in a very bad manner by making the editing to those pictures or the images. Very close images of the children and women can be taken by different technological measures, and they may be used in such a way by the offenders of this cyber world. The cyberbullying can be made in the form of doxing. Doxing is the finding, manipulating and publishing private information to the public or a group of known about someone non-consensually to cause trauma, shame, fear, intimidation to that person. So, whenever any such private information is manipulated, private information is published in a public group or in the group of the knowns of a person, then the person whose private information is published in such a way without his or her consent, it causes the mental trauma, it causes the shame, it causes the fear, it causes the intimidation to the person. Nowadays, we see that the women and children, they have to be very cautious in using social media platforms, in posting their images or their private informations on these different social media, because very easily the others can use they can find this information, they can manipulate this information, and after finding and manipulating this information, they can, without the consent of the person to whom that information belongs, they can publish this information publicly or in the group. So, it is the cause of mental trauma, it is the cause of the shame, it is the cause of the fear, it is the cause of intimidation of a person to whom that information belongs. The cyberbullying can also be done in the form of cyber stalking. This is the most common form of cyberbullying. By following the geotags used in social media posts or following the individual by use of electronic devices to get the details of live locations, residential addresses, email address, to misuse the information to cause threat or violence to that individual. It has become very easy for the offenders to do or to follow the women and children in such a way. So, cyber stalking is also one form of cyberbullying. What is the international mandate or what is the international law with regard to the protection of the rights of the children from such cyberbullying, or the protection of the women and children from such kind of offences under the offence of cyberbullying? United Nations Convention on the Rights of Child. Again, we are to refer to the CRC, United Nations Convention on UN Convention on Child, the Rights of Child. According to Article 2, Clause 2 of the Convention, every child should be protected from all forms of discrimination or punishment based on status, opinions, actions or beliefs of the parent, legal guardians or family members' opinions. This convention seeks to protect children from violence, injury, abuse, exploitation, negligent behavior and sexual harassment. And all of it is done, all this is done by way of cyberbullying. By cyberbullying, the violence is caused to the women and children, the abuse of the pictures, the informations relating to private informations, private images of the individuals, of the women and children is made, and it also amounts to the sexual harassment. Then United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985. Article 1.3 provides for effective mobilization of the juveniles who were in conflict with law along with their family and all the relevant resources to facilitate their schooling and other community institutions that are important for their development, free from any kind of discrimination. So, it is also important that when any child become the culprit of the cyberbullying, then it is certainly the impediment, this is certainly the hindrance in the schooling of that child, because of the fear which arises out of such cyber offences or cyber crimes. Sometimes we see that the children, they stop to go to the school. Universal Declaration of Human Rights, Article 25, Clause 2 provides for equal social protection for all children, whether born in or out of wedlock. The bullying and harassment has become the major social concern for protection of children's rights. Under Article 26(3), parents have the right to choose the manner of education of their children. So, these are the provisions which indirectly deal with the problem of cyberbullying. Optional protocol to the Convention on the Rights of Child on sale of children, child prostitution and child pornography. By way of internet media, the child pornography has become very big offence. Article 1 of this optional protocol provides that state parties shall take positive action in prohibiting child prostitution, child pornography and sale of children. Article 9 clause 4 of the protocol states that child victims of the offences mentioned in protocol should have access to adequate measures to claim compensation for damages without any discrimination. So, this is the international mandate, and we see that different provisions in international law, they indirectly deal with the problem of cyberbullying. Constitutional mandate, if we see, again we are to refer Article 15 and Article 21 of Indian Constitution. The Constitution of India on one hand provides for rights to equality under Article 14 and provision of discrimination on the ground of sex under Article 15. But under Article 15(3), it enables the state for making any special provision for women and children. Therefore, the Constitution empowers the state to make special provisions for the betterment of women and children, mental health and safety. So, this mandate of Constitution under Article 15(3) gives the authority to the state to come up with the rules, regulations and administrative initiatives or the legislative initiatives to tackle the problem of or to deal with the problem of the bullying, cyberbullying to the children and the women. Article 21. Under the present article, right to life and personal liberty are considered to be the essential pillar of human life. Right to life and personal liberty, these are the inherent rights of the human personality. These are natural rights, these are very basic rights, and it is considered that these are inseparable rights, these are inalienable rights. The person cannot be alienated, or these rights cannot be alienated, these rights cannot be separated from the personality of an individual. These are integrated rights. By interpreting this, Supreme Court held that human life should not be associated with mere animal existence. It denotes life with dignity in the case of Maneka Gandhi versus Union of India. And when Article 21 includes the right to live with human dignity, then certainly this is the obligation over the state, this is the duty of the state to protect the children, to protect the women against any kind of such offence or crime, any kind of such internet communication by way of internet media, or any offence of cyberbullying which in any way infringe the right to life and personal liberty, or it is contrary to, or it is, or which decreases the dignity or which demeans the dignity of an individual. So, if by way of cyberbullying or by way of doxing, by way of stalking, or by way of cyber voyeurism, by way of cyber flashing, if there is any compromise with the dignity or there is any attack on the dignity of an individual, then it is that right can be enforced against the state, and the state becomes duty bound to provide for the remedy against any such kind of violation of fundamental rights. It is the duty of the state to make the law, to take the initiatives for protecting the women and children from cyberbullying under the mandate given by Article 21, that is right to life and personal liberty. Article 47 of Indian Constitution imposes the duty on the state to raise the level of nutrition and the standard of living and to improve public health. this article makes the provision to improve the improvement of the public health a major and the primary duty of the state. So, not only the physical health, the mental health also belongs very closely to the physical health, and therefore, it is the duty of the state to protect the mental health and the physical health of the public. If anyone is harassed, any child or any woman is harassed by way of the cyber stalking, by way of the cyber voyeurism, by way of the cyber bullying in general, then it is the duty of the state to protect that person from any such attack on his or her mental health. Article 51E. Again, it is the fundamental duty of the citizens of the country to renounce any such practice which is derogatory to the dignity of the woman. This fundamental duty directs the citizens that they should renounce any such practice which is derogatory to the dignity of the woman. The practice of such cyber offences or the such cyber practices which are being done by the cyber offenders are violative of, or these are demeaning the dignity of the woman, and certainly the citizens should be aware of their duty and they should not do any such thing, or they should not take part in any such activity which is in any way derogatory to the woman's dignity. So, what are the legislative initiatives with regard to the problem of cyberbullying? The Information Technology Act, it comes at first place in all the legislative initiatives being evolved to tackle with such problems. In the year of 2000, the Information Technology Act was enacted by Indian legislature, and if we see the preamble to this Information Technology Act, it clarifies that it is an act to provide legal recognition for transactions carried out by means of electronic data, interchange and other means of electronic communication, commonly referred to as electronic commerce, which evolved the use of alternatives to paper based methods of communication and storage of information. It is also the objective of the Information Technology Act to facilitate electronic filing of documents with the government agencies, and further to amend the Indian Penal Code, the Indian Evidence Act, the Blankers Book Evidence Act, the Bankers Books Evidence Act and the Reserve Bank of India Act 1934, and for matters connected therewith for incidental thereto. So, it is also the objective to make the amendments accordingly in other enactments. Section 66A of the Information Technology Act. This provision directly tackles with the issue of cyber bullying, and therefore, this section 66A of Information Technology Act is the most significant provision for the purpose to deal with the problem of cyber bullying or to protect the women from the vice of cyber bullying. This section 66A penalizes sending offensive, annoying, intimidating, hating, insulting, dangerous information through a computer resource with imprisonment for a term up to 3 years and fine. So, the problem of cyberbullying or the problem of the transmission of the information in such a way which may be offensive, which may be annoying, which may be intimidating, or which may create the hate, or which may be insulting, or which may be dangerous. If any such information is sent or if any such information is communicated through a computer resource, through the internet media, then this offence is punishable with the imprisonment for a term up to 3 years and fine. But in order to preserve unwarranted penalization by the government by restricting freedom of speech, this provision was held unconstitutional in the case of Shreya Singhal versus Union of India in 2015. Now see, this was the provision which was very effective, which could be very effective problem to deal with the problem of cyberbullying. But in 2015, this provision was declared to be unconstitutional in the case of Shreya Singhal versus Union of India. Section 66E, this provision deals with the issue of violation of privacy, where someone non-consensual intentionally or with knowledge captures, publish or transmit images of private areas would be punished with the imprisonment that might extend to 3 years or with fine up to 2 lakh or with both. Now see that section 66E is certainly a provision of the Information Technology Act 2000, which may effectively deal with the different aspects of the crime or the offence of cyberbullying, because this provision deals with the issue of violation of privacy. Number one, the violation of privacy is always involved in the cases of cyberbullying, and this provision deals with the circumstance or the situation where anybody without the consent and having the intention or knowledge captures the images of any private area of a person, publish these pictures, transmit these images, is to be punished with the imprisonment that might extend to 3 years or with fine up to rupees 2 lakh. The imprisonment or the punishment which has been provided under section 66E, that is of maximum 3 years. The minimum punishment has not been prescribed. In such a serious offence, it may be recommended that the provision may be amended accordingly and the minimum punishment should be provided so that that provision may be more effective, more efficient to deal with this new crime of cyberspace, that is the cyberbullying. Then section 67A. In this section, punishment for publishing or transmitting material containing sexually explicit act in electronic form is prescribed as is punishable with the punishment of imprisonment up to 5 years and fine up to 10 lakh for first conviction, and for subsequent conviction imprisonment up to 7 years and fine up to 10 lakh. Section 66E deals with the situation where without the consent of a person, without the consent of any woman, without the consent of any child, any images of the private area of that person are captured, these are transmitted, these are published, then such a person is punishable under section 66E with the imprisonment up to 3 years and a fine up to rupees 2 lakh. But 67A, it deals with the publication and transmission of any material, not only the images, the publication and transmission of any material containing sexual explicit act. So, if any information or any material which is published or which is transmitted, it has any element of sexuality, then the person is to be punished with the imprisonment up to 7 years and the fine of rupees 10 lakh at first conviction, the imprisonment up to the 5 years and the fine of 10 lakh rupees at first conviction, and at the second or subsequent conviction the punishment up to the imprisonment for 7 years and the fine of rupees 10 lakhs. Here also the minimum punishment may be fixed to make the provision more effective. For both the instances, when the offence is committed at first time, that may be minimum and maximum, and when the offence is committed at subsequent or the second time, then again the minimum punishment should be fixed. Section 67B. See section 67B. If any person, number 1, publishes or transmits material in any electronic form which depicts children engaged in sexual act or conduct, 2, creates text or digital images, collects, seeks, browses, downloads, advertises, promotes, exchanges or distributes material in any electronic form depicting children in obscene or indecent or sexually explicit manner, C, cultivates, entices or induces children to online relationship with one or more children for and on sexually explicit act or in a manner that may offend a reasonable adult on the computer resource, or D, facilitates abusing children online, E, records in any electronic form own abuse or that of others pertaining to sexually explicit act with children, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction with imprisonment of the term description for a term which may extend to 7 years and also with fine which may extend to 10 lakh rupees. This is the detailed provision of section 67B. Under section 67B again we can recommend that the minimum punishment should be fixed. The minimum has not been prescribed, and therefore it is recommended that minimum punishment may be prescribed. Indian Penal Code 1860 and Bharatiya Nyaya Sanhita 2023. Indian Penal Code 1860 and Bharatiya Nyaya Sanhita 2023. We know that Indian Penal Code was the substantive criminal law in India, and now it has been replaced by Bharatiya Nyaya Sanhita. Section 292 IPC and section 294 BNS refers to the offence of obscenity. Earlier in IPC, section 292, 293, 294, these were related to the offence of obscenity. Now these three provisions are replaced by section 294, 296 and 297 of Bharatiya Nyaya Sanhita respectively. This provision in IPC penalizes selling, distributing, advertising of a physical thing that would be deemed as obscene, with punishment on first conviction of imprisonment up to 2 years and fine up to 2000 rupees, and at subsequent conviction of imprisonment up to 5 years and fine up to 5000. In BNS, punishment on first conviction of the imprisonment up to 2 years and fine of rupees 5000, and on subsequent conviction of imprisonment up to 5 years and fine up to 10,000 rupees. This provision, you can see the changes which were brought in by the Indian legislature in Bharatiya Nyaya Sanhita as compared to the provision, earlier provision in IPC. Section 294 IPC and section 296 of Bharatiya Nyaya Sanhita. This provision in IPC punishes any obscene act in public place, singing or uttering obscene songs, to cause annoyance to others, with imprisonment for a term up to 3 months or with fine or both. In BNS, it is punishable with imprisonment up to 3 months or fine up to rupees 1000 or with both. Then section 354 in IPC and section 75 in BNS. This section provides for defining of sexual harassment and its punishment. Sexual harassment has been defined as any act of physical contact involving unwelcome sexual overtures or sexual act, demands or request, or showing pornography without consent or making sexually colored remarks. For the first 3 acts, the punishment is rigorous imprisonment for a term up to 3 years or with fine or both, and for the last act, simple imprisonment for a term up to 2 years or with fine or both. This can also be used in the matter of cyberbullying, the sexual harassment at the workplaces, sexual harassment of the women at workplaces, sexual harassment of the children at their schools. This is the problem of bullying. It may be made directly or by electronic media, both. So, when there is any showing of the pornography without the consent of the person concerned, even with via media of internet, should be included within 354A. 354C in IPC and section 77 of BNS. In this section, voyeurism has been made punishable with punishment on first conviction of imprisonment from 1 year up to 3 years and fine, and on subsequent conviction of imprisonment from 3 years up to 7 years and fine when the victim consent the filming of the act but not the dissemination. It would also be considered punishable in the section. So, if these sections of IPC are read with the provisions of Information Technology Act 2000, then that may be a very strong regime to protect the women and children from this offence or the crime of cyberbullying. Section 54D in IPC and section 78 in BNS, the stalking has been punished under section 54D of IPC and now it is 78 of BNS. For stalking, the punishment has been provided on the first conviction for the term imprisonment for a term up to 3 years and fine, and on subsequent conviction the imprisonment up to 7 years and fine. Section 500 of IPC and 356(2) in BNS, defamation has been made punishable in this section with simple imprisonment of a term up to 2 years or fine or with both. Likewise, section 504 IPC and 352 of BNS, it penalizes intentional insult that are made to provoke a person to either cause him to break public peace or an offence by imprisonment up to 2 years or fine or both. Section 509 IPC and section 79 of BNS. This section penalizes words, gestures or act done to insult the modesty of a woman or to intrude upon the privacy of such woman by imprisonment up to 3 years and fine. You can see that the provisions of IPC and the provisions of Information Technology Act, these are aimed at dealing with the same kind of offences, same kind of crimes. When these are done on cyber space or in cyber field, then the provisions of Information Technology Act are applicable, and when these are done otherwise, the provisions of IPC may be applicable. But we should understand that the Indian Penal Code and now the Bharatiya Nyaya Samhita, it is the mainstream criminal law, substantive criminal law in our country. And therefore, the punishments which are being provided for the same offences in Information Technology Act should be at par with the punishments being provided by the provisions of IPC. I think that the provisions of Information Technology Act and the provisions of Bharatiya Nyaya Samhita should be read together. And it may also be suggested that when these offences are done by electronic media, through internet media, through cyber technology or cyber techniques, that should also be included within the provisions of IPC. If any such act is done under different provisions in the Bharatiya Nyaya Samhita, the punishments have been prescribed. So, the legal regime in India seems to be very sound in relation to protect the women and children from cyberbullying. It cannot be said that the legislative initiatives have not been taken, but there is a need to enforce or implement these legislative provisions, these legislative initiatives in accordance with the modern developments or modern changes. These should be interpreted accordingly. It may be done that even the provisions of Bharatiya Nyaya Samhita may also be interpreted to include such offences being done through the cyber space. Now, we are to see the judicial approach. What has been the judicial approach with regard to the protection of women and children from cyberbullying? Cyberbullying involves a very important constitutional, fundamental, natural human right, that is right to privacy. By way of cyberbullying, in all the instances of cyberbullying, if you see carefully, the right to privacy of any woman, the right to privacy of any children is being attacked, is being infringed, is being violated. And therefore, Article 21 may also be the remedy against such kind of offences in the name of cyberbullying. If we see the status of right to privacy under Article 21, recently in 2017, one case was decided by the Supreme Court of India, that is KS Puttuswamy versus Union of India. 9 judges bench of the Supreme Court in 2017 in this case held that right to privacy as the fundamental right under Article 21 which includes the right to privacy in virtual or cyber space. This is very important, very significant development in the direction to protect the women and children from any attack by cyberbullying. When the Supreme Court says that right to privacy is the fundamental right under Article 21 and it includes the right to privacy in virtual or cyber space both, in virtual and cyber space. Since the scope of the virtual world is expanding continuously, this judgment becomes more relevant and essential because right to privacy in cyber and virtual world has also been recognized by our Supreme Court in the case of KS Puttuswamy versus Union of India. Now, if we see the case decided by the court in the name of State of Tamil Nadu versus Suhas Katti, this case is considered as the first case where Section 67 of the IT Act 2000 was applied and the accused was used Yahoo Messenger to send the accused who used Yahoo Messenger to send annoying defamatory messages in a group of divorcee women was convicted under section 469 and 509 of IPC along with section 67 of IT Act. So, it seems that the approach of the court in the case of state of Tamil Nadu versus Suhas Katti is very progressive when the provisions of Indian Penal Code and the provisions of the Information Technology Act 2000 were read together, and the provisions of these two enactments were applied together, and accordingly the punishment was made. And therefore, we can say that the integrated approach of the governmental agencies, integrated approach means the integration of the provisions of these two laws, the integration of the Bharatiya Nyaya Samhita provisions in Bharatiya Nyaya Samhita to protect the women or dealing with the offence of bullying, and the provisions of Information Technology Act to deal with the problem of cyber bullying. These are needed to be, these are required to be read together, and accordingly the offences or such crime is to be dealt with. There is a case of Ritu Kohli. This case was the first case of cyber stalking in India, which led to the 2008 amendment to the IT Act 2000. How the new techniques of the crime offences, they assist or they encourages, motivates, gives the opportunity to the legislature to make the amendments in the laws accordingly. The Ritu Kohli case is the example. This was the case of cyber stalking, and though the IT Act was there, but it was not sufficiently capable of including such offences, and therefore in 2008 the amendment was made. In this case, a man used the name of Ritu Kohli on some messaging site to talk in explicit manner and disclose the personal information such as phone number and address, which led to the harassment of Ritu Kohli in real life, where she was getting obscene calls and messages from strangers who got unauthorized access of their personal information virtually. As the consequence of this particular case decision, the amendments were made in 2008 in IT Act. Now see section 509 of IPC. This 509 IPC was felt insufficient in dealing with the case, and this led to the major amendments in Information Technology Act 2000. So, this process of integration of the laws by the enforcement machineries and by the legislature is the welcome step towards protecting the women and children from cyberbullying. There is the case of Air Force Wal Bharati School versus Delhi Tribunal 2001. Division Bench of Delhi Court dealt with the case that involved making of a pornographic website by one of the male student about the female students and teachers, in which the court decided the matter containing the section 67 of IT Act 2000. In Banji.com case, a video of sexual act was recorded with consent of the girl, but was later non-consensually distributed and published at website, which led to unregulated visibility of the video to the world and circulation among many. This case was sheer instance of lenient laws letting culprit walk free and victim getting the want of inaction by law and order. And therefore, it is suggested that in the matters of cyberbullying, this is the duty of the state, this is the duty of government machinery to apply the law in very strict manner. The strict interpretation of laws should also be made, so that the victims of such cyberbullying may be protected and they may be given the remedy. Thank you very much.